Excellencies, ladies and gentlemen, it is my honor to welcome you to this special event on equal access to justice for all, a topic that is crucial for achieving sustainable development and ensuring peaceful, just, and inclusive societies. With the adoption of SDG 16, the international community undertook to promote the rule of law at national and international levels and to ensure equal access to justice for all. Equal access to justice is a key component of fair, humane, effective, and efficient criminal justice system. So all groups in society can equally enjoy their rights. It is also at the heart of equality and non-discrimination requirement and overarching objective of a 2030 agenda to leave no one behind. Yesterday, during his address to the Congress, the Secretary General highlighted that people need an inclusive justice system that works for all and is intolerant to discrimination. UNODC's approach to enhancing access to justice is based on an understanding that to truly realize this objective, all those affected by crime must be able to seek redress. There is a need to fully safeguard the rights of alleged and sentenced offenders and their human treatment during and after criminal proceedings. To enable people to make better use of the law and legal services in the protection of their rights, and to protect and assist victims impacted by crime. The challenges created by COVID-19 have had a massive impact on access to justice in many countries and have put a spotlight on the importance of human rights-based policing, access to legal aid, restorative justice programs, and services for victims. And they have also shown that strong mechanisms to guarantee all those are often lacking. Expert speakers in today's event will highlight solutions, ideas, and approaches, while looking at the issue from different angles and sharing their national experiences for us to learn from them. The event is co-sponsored by our partners, the Ministerio Público de la Defensa of the Republic of Argentina, the United Nations Development Programme, UN Women, the International Development Law Organization, IDLO, the Pathfinders for Peaceful, Just and Inclusive Societies, and the Union Internationale des Avocats. I would like to thank all of you for your many years of cooperation and partnership with UNODC in delivery of assistance, development of guidance and tools, and for actively promoting access to justice, from multilateral forums to activities in local communities. It is my pleasure now to introduce to you Ms. Ghada Wali, Executive Director of the United Nations Office on Drugs and Crime, UNODC, and Director General of the United Nations Office at Vienna, to deliver opening remarks. Her intervention will be followed by a video developed by the elders who promote access to justice as an important human right through a strong focus on enhancing access to justice for women, working with grassroots initiatives and locally based civil society organizations. They uphold the belief that all sectors in society must step up and take responsibility to deliver access to justice to the most vulnerable individuals and communities. And now we will hear the Executive Director of UNODC and the elders who will address us through video statements.
Excellencies, ladies and gentlemen, equal access to justice is fundamental to the rule of law. And yet, far too often, the poor and the marginalized, women, children, persons with disabilities, migrants and minorities are unable to seek redress, make their voices heard, or defend their rights in the criminal justice system. COVID-19 restrictions are further perpetuating vicious cycles of exclusion and injustice. The 14th UN Crime Congress provides a timely opportunity to explore measures for ensuring access to justice for all and commit to their urgent implementation. At this important event, we will hear from justice sector officials and practitioners on how to help all members of society exercise their legal rights. The UN Office on Drugs and Crime is working with countries across Asia, Africa, and the Middle East, as well as Latin America and the Caribbean, to adapt legislation and policies to enable equal access to justice. Our office builds capacity to help police and justice institutions, as well as providers of legal services, to empower those at risk of being left behind. UNODC promotes inclusion through restorative justice, enhancing access to legal aid, police reform, support to victims of crime, and the application of standards to uphold the rights of prisoners. We have also developed technical guidance for practitioners, including a recent joint publication with UNDP. I would like to thank our partners from within the UN and beyond for their cooperation with us and for co-organizing today's event. UNODC looks forward to continuing and strengthening collaboration to promote equal access to justice for all. On this note, I'm pleased to inform you that our office is currently finalizing a memorandum of understanding with the International Development Law Organization. By joining forces to promote the rule of law, we can accelerate progress towards Goal 16 of the 2030 Agenda, dismantle barriers to active participation in justice processes, and build accountable and inclusive institutions that uphold the rights and dignity of all.
More than 5 billion people don't have meaningful access to justice. It actually hurts me to say that.
World leaders committed to access to justice for all when they agreed to the Sustainable Development Goals in 2015.
But international donor funding for access to justice has decreased by 40% over the past 4 years. This is unacceptable.
The elders are calling on all leaders to make good on their ambitious commitments.
We want to see increased financial investment in community legal empowerment initiatives,
more funding of access to justice for women and services for survivors of gender-based violence.
More priority given to civil justice, while not forgetting the importance of criminal justice.
Injustice is very closely linked to inequality, to discrimination.
Injustice on this sweeping scale should shame us all.
We need action now.
I would like to thank Ms. Wally and the elders for their inspiring words. We are honored to have with us senior officials from 4 different regions who will now address the challenges and responses to access to justice prior, during, and after the COVID pandemic. We will be listening to video statements from the Lord Chancellor and Justice Secretary, the Right Honourable Mr. Robert Buckland, QCMP from the United Kingdom, the Honourable Ms. Alison Gibson, QC, former Attorney General and Minister for Legal Affairs of the Bahamas and member of the Task Force on Justice, the Honorable Dr. Stella Maris Martinez, Federal Public Defender General of Argentina, and the Honorable Mr. Tag Isir El Ibir, Prosecutor General of the Republic of Sudan. Distinguished speakers, the floor is yours.
Principle that every person should have equal access to justice is at the very heart of our system here in England and Wales. The United Nations Congress is the largest and most diverse forum in the area of crime prevention and criminal justice, and has an important role in shaping policy discussions, practices, and commitments by the international community. Under Sustainable Development Goal 16, we have committed to promoting the rule of law in our national systems and internationally, and to ensuring equal access to justice for all. The rule of law depends upon our criminal justice systems working for all, and the UK supports UNODC's work in this area. Without effective and fair criminal justice systems, it's hard to make a sustainable impact against criminality. As an international community, we must take actions to ensure equal access to justice for all, including for vulnerable people, regardless of their status. This means ensuring that everyone is treated with respect and without discrimination. At the most basic level, it means that the doors of justice must be open to all people, which is why we spent £1.7 billion on legal aid last year and worked closely with stakeholders across the legal advice sector to develop and improve other forms of legal support. But there are court users for whom equal access is about more than just the availability of funding. Those with vulnerabilities and special needs require extra support throughout the process to ensure that not only are the doors of justice open, but that they have every opportunity to walk right through them. Being able to provide that help begins by understanding the challenges that vulnerable people face in the justice system. Both our court system and the legal profession in our country are providing staff and practitioners with practical support and evidence-based guidance on how to treat vulnerable people with dignity and respect, and how to design and to deliver services with vulnerabilities in mind. A range of special measures is available at the discretion of our courts to help vulnerable witnesses to give their best possible evidence. These include screens to prevent them coming face to face with defendants who might have caused them harm, intermediaries to support them to communicate effectively, and opportunities for them to give evidence via video link or to have it pre-recorded. Some of these measures are rightly available to vulnerable defendants too, who have as much right as anyone to give the best possible account of themselves in court. Over the last 12 months, COVID-19 has had huge implications for the operation of our court system. As the full consequences of the pandemic became clear, we acted quickly to make the courts COVID secure so that we could keep people safe from the virus. We employed extra staff, and we've made hundreds of additional courtrooms available so that the system could react as larger accumulations of cases waiting to be heard than usual grew. And we've invested heavily to modernise our court buildings and to improve technology so that we could continue to deliver services remotely, including through the provision of audio and video hearings where appropriate. We worked in partnership with the judiciary, court staff, the legal profession and court users to plan and to execute these changes, but with minimal disruption to services. But we were very much aware that vulnerable court users would need extra support to mitigate against any unintended consequences. So we published a vulnerability action plan, setting out how we would ensure that any changes did not disadvantage or discriminate against them in any way. We also contributed to efforts to ensure that other justice services, such as those provided by the not-for-profit sector, could continue offering support, including to vulnerable people, by making emergency funding available to help them to adapt their operations to new ways of working. And as we begin to move beyond the pandemic, I am keen that we continue making as much use of new technology as we can. But I'm very much aware that vulnerable court users can have limited access to digital infrastructure, and in some instances, online solutions simply are not appropriate for them. So our focus in the months and years ahead will be on determining which innovations we should build upon, so that an increasingly modernised justice system continues to be open and inclusive to all users, including the most vulnerable. And more broadly, we will continue making sure that vulnerable people can engage with a full range of justice services. Our court service has recently begun work on collecting more consistent and higher quality data on protected characteristics, so that we can better understand and address the needs of vulnerable people right across the justice system. And one particular area of focus for us will be neurodiversity in the criminal justice system. Specifically, how we can tailor services to meet individual needs so that we can provide more effective pathways to rehabilitation and prevent reoffending. Equal access to justice is a noble principle to which we are all rightly committed. Over these last 12 months, I'm sure for you, like me, it has felt at times as if keeping the doors of justice open to anyone was an achievement just in itself. As we all strive to deliver solutions to the common challenges that we face because of COVID-19, it reinforces the importance of global cooperation and collaboration. And I hope that we can commit to continue to learn from each other and to share best practice on what really works, and raising standards globally, so that collectively we can keep the doors of justice open to everyone.
I've often heard it said that when written in Mandarin, the word crisis is composed of two characters. One represents danger and the other represents opportunity. The pandemic places us on the pathway of opportunity, which must be seized if we are to achieve the SDG 16 goal of peace, justice, and strong institutions. I was a member of the Task Force for Justice, and I commend its Justice for All report. Our struggles and access to justice are shared across the globe, from the Bahamas to the United States to Sierra Leone, Argentina, and the Netherlands. In different cultures, they may present differently, but the bottom line is that people experience justice problems no matter where they live, and that institutions are not delivering fair outcomes. In 2012, when I became the Attorney General and Minister of Legal Affairs in the Bahamas, there was considerable cynicism about the efficacy of our legal system. Far too many rape and murder matters were taking 6 to 10 years to come onto trial. These delays denied justice to victims and alleged offenders and their families. I was privileged to lead national and international stakeholders who were committed to combating this crisis through communication, cooperation, and collaboration. We launched a program called Swift Justice, whose focus was to provide the framework by which all stakeholders in the administration of justice could work together to swiftly bring matters on for trial and engender confidence in fair outcomes. Some of the outcomes on this collaboration were: days to present a voluntary bill of indictment decreased by 277. 112 more serious matters were tried in 2015 than in 2012. 10 criminal courts were 21st century technologically equipped, and an Office of the Public Defender was established. One of the human impacts of the changes was that families of victims of murder could now have resolution of a matter within a reasonable time after burying their loved one, rather than 10 years later. Let's fast forward to 2021. What opportunity exists in the COVID crisis? An important opportunity is for justice leaders to do what public health leaders routinely do: come together to exchange best practices for rapid, just, and people-centered action. When the pandemic hit, the Justice Leadership Group worked with a large group of justice experts on 2 briefings on justice in a pandemic. The first was Justice for All in the Public Health Emergency, where we advocated that justice actors on the front line, like public health actors, must be protected. Emergency measures curtail human rights. Therefore, it is important that political leaders be held to account, safeguards be introduced for at-risk communities, and justice actors be supported in their work in partnership with community leaders to safeguard human rights. Across the world, mobility restrictions increase women's vulnerability to abuse. Some survivors report being unable to seek legal redress due to court closures. Further, the first responders are overwhelmed or have shifted priorities. UN Women has called domestic violence a shadow pandemic. The pandemic ushered in an overnight shift to technology and innovation. Justice leaders are following public health example of giving service online. Increasingly, we are seeing the political will to partner with communities and to support innovation so that grassroots and other community workers can help people resolve their problems in their communities. The danger of the spread of COVID-19 in prison has also led to courts more and more utilizing restorative justice principles. Also, to reduce the demand on the justice systems, governments are encouraging law enforcement officials to cease arresting people for minor offenses. The second briefing, Justice for All and the Economic Crisis. The economic impacts of the pandemic have also increased the number of justice problems people face related to unemployment, evictions, divorce, and so forth. At the same time, justice actors are under increased pressure. Resources are limited, and they are restricted in their ability to move about to give services. Different types of crime have also emerged, with fake PPE being sold, fake systems to get vaccination appointments, and other schemes to defraud individuals. And there are serious problems in the procurement processes in places as diverse as Malawi and Philadelphia. The justice response, equivalent to a vaccine in the public health context, requires a systemic shift. Reliance on data is critical. In rapidly changing circumstances, it's even more important to collect data, to understand people's justice problems, their experiences on their justice journey, and analyze what does and does not work. The pandemic unleashed a wave of innovation. Pilot projects with remote courts and digital systems were scaled up rapidly. Now is the time for justice leaders to look at what worked, what to keep, and what to improve. Public resources will remain under stress, and the number of justice problems is high and rising. Now is the time to rethink justice services. Can we be smarter, more efficient, more pleasant, more people-centered? The new and creative partnerships created in response to the pandemic, hopefully, will lead to the understanding that justice is the golden thread through all of the SDGs and the foundation of all strong societies. Pope Francis said, and I quote, "A worldwide tragedy like COVID-19 momentarily revived the sense that we are all a global community, all in the same boat, where one person's problems are the problems of all. Once more, we realize that no one is saved alone. We can only be saved together," end quote. So that we can be saved together, public health leaders are finding ways to make vaccinations available to all. Justice leaders must take it global. I invite you to 3 commitments that every country and all justice leaders can make to accelerate people-centered justice for all. Encourage the trend of justice leaders meeting virtually at regional and sub-regional forums to support innovation and develop shared strategies for tackling the economic crisis. Reinforce the understanding that the movement for justice for all people undergirds the SDG targets for inclusive growth, decent jobs for all, the economic empowerment of women, and indeed, all of the SDG targets. Encourage your governments to influence international financial institutions, G20 finance ministers, and other platforms for international economic policy making to put justice at the heart of the global response and recovery. Please remember that we are all in the same boat, and we all achieve more when we row together in the same direction. Together, we can achieve equal justice for all.
Hola, soy Estela Maris Martínez, soy la Defensora General de la República Argentina y en este momento soy la Coordinadora General de la Asociación Interamericana de Defensorías Públicas. En primer lugar, quiero agradecer la enorme honra que significa estar invitada a participar en este importantísimo evento. Mi primer agradecimiento entonces va a ser para la Oficina de las Naciones Unidas contra la Droga y el Delito. A su vez, quiero agradecer también a los países que copatrocinan este evento en particular, y al gobierno de Japón, que es el huésped, el anfitrión, del 14º Congreso sobre Prevención del Delito y Justicia Penal. A todos ellos, mi más profundo agradecimiento. Quiero contar un poco, en esta oportunidad que se me da, qué es lo que hace el Ministerio Público de la Defensa de la República Argentina y al mismo tiempo reflejar lo que hacen muchas defensorías públicas de América con un menor o mayor grado de autonomía, con un menor o mayor grado de especialización, pero todas colaborando en la lucha para lograr el acceso a la justicia de los sectores más vulnerables. Yo soy la defensora general, como dije, de la República Argentina, la cabeza del Ministerio Público de la Defensa. Esta institución es una institución que integra el sistema de administración de justicia. Es autónoma, esto quiere decir que no depende de ningún otro poder, ni siquiera del Poder Judicial, pero tampoco, mucho menos, del Poder Legislativo o del Poder Ejecutivo. No recibe órdenes, sugerencias ni instrucciones de ningún otro poder del Estado. Y también es autárquica, lo cual es muy importante, ya que al tener su propio presupuesto y poder administrarlo fijando sus prioridades, logra que la independencia y la autonomía de la que es dotada por la Constitución Nacional, además de por su ley orgánica, se haga una realidad. Nuestro trabajo, que es muy grande, muy importante, está realizado por defensoras y defensores públicos y también por funcionarias y funcionarios que colaboran con ellos y empleados y empleadas. Todos ellos, obviamente los defensores y las defensoras y los funcionarios y funcionarias necesariamente, pero también gran parte de los empleados cuentan con título de abogado. Y todos llegan a este cargo, a sus cargos, luego de haber rendido un examen sumamente riguroso. A ellos se les suma que están sometidos a un sistema de capacitación continua que brinda la propia institución. Nuestra defensa es una defensa integral. Esto quiere decir que trabajamos en el ámbito tanto de la justicia penal como en el ámbito no penal, civil, administrativo, laboral. En el caso de las causas que tramitan ante la justicia penal, siempre que un acusado, y desde el primer momento en que es acusado, precisa un abogado y no nombra un abogado particular, automáticamente va a ser asesorado por un defensor público. Este defensor público, que se designa conforme a un sistema de turnos, es un funcionario del Estado que cobra un salario del Estado y que va a asesorar a esta persona, va a ejercer su defensa en todas las instancias, desde el inicio de la causa hasta la etapa de cumplimiento de pena, si hay pena. Aparte de esto, también actuamos en el ámbito de la justicia no penal. Esto es la justicia, como dije, civil, laboral, administrativa. Aquí sí, básicamente asesoramos a personas que no tienen recursos. Si la persona cuenta con recursos, deberá designar un abogado particular. Pero si se encuentra en situación de pobreza, el Estado le garantiza el patrocinio mediante nuestra institución. Este patrocinio es sumamente activo, sobre todo cuando se refiere a personas especialmente vulnerables, a adultos mayores, a personas que tienen algún tipo de jubilación, pensión estatal. Este es un trabajo que, para preservar la vida, la salud y los ingresos de las personas más vulnerables, realizan con gran esfuerzo todos nuestros defensores. Además de ello, dentro del ámbito de la defensa pública de Argentina, tenemos un sistema para abordar los casos de las personas en situación de vulnerabilidad. Esto se organiza mediante un modelo de programas y comisiones que funcionan dentro del ámbito de la Defensoría General de la Nación, que es el órgano rector del Ministerio Público de la Defensa, y allí trabajamos de manera especializada con migrantes, refugiados, refugiadas y también con apátridas. También trabajamos con personas con problemas de salud mental, con niños, niñas y adolescentes. Tenemos un trabajo especializado para las víctimas de violencia institucional, y también en la protección de las víctimas de delitos. Para ellas, especialmente para las víctimas carentes de recursos, existe un programa de patrocinio, por lo cual si quieren intervenir, tal y como los instrumentos internacionales garantizan que la víctima tiene derecho a hacerlo, pueden intervenir en los procesos penales mediante el patrocinio jurídico, el asesoramiento y el acompañamiento técnico jurídico que le brinda un programa especializado de la Defensoría General de la Nación. Este ha sido un modelo muy exitoso que ha sido por ello receptado por nuestras autoridades legislativas, que han dictado una ley de protección de las víctimas para garantizar todos los derechos a las víctimas, y entre ellos los derechos y la protección que se le brinda, han creado la figura del defensor público de la víctima. Se han creado 24 defensores que cubren todos los estados de la República Argentina y que en este momento, luego de un riguroso examen, están comenzando a ser designados para brindar un patrocinio específico y de alta calidad a todas las personas que sean víctimas de delitos y que no puedan, que quieran participar, que quieran ser asesoradas y no puedan costear un abogado particular. También tenemos un trabajo muy fuerte en todo lo que tiene que ver con los derechos de las mujeres en general y con las víctimas de violencia de género en particular. Hemos sido pioneros en la creación de un sistema de patrocinio por el cual nuestra institución le brinda patrocinio jurídico no penal a todas las víctimas de violencia de género. Aquí no importa que tengan o no tengan dinero, porque se considera que por su situación de vulnerabilidad siempre deben tener el derecho, esto lo dice la ley, de contar con el patrocinio jurídico adecuado. Este es un trabajo muy importante que realmente ha garantizado el acceso a la justicia de numerosas mujeres víctimas de delitos. También hay otro tipo de experiencias destinadas a generar una defensa específica para las autoras, mujeres, en casos de violencia reactiva. Es decir, esta situación es ignorada y son condenadas por esta circunstancia. En eso hemos trabajado mucho en un proyecto financiado por Social Justicia, que es un programa de la Unión Europea. Se ha elaborado un manual y se ha hecho en este momento un proyecto de capacitación para poder establecer pautas de defensa mejorada y diferenciada para estos supuestos. También se ha trabajado con la misma perspectiva para el caso de las mujeres que integran grupos de tráfico de droga, las escalas más bajas en la jerarquía del trabajo ilícito de transporte de droga y que muchas veces son equiparables a una víctima de trata de personas. En esto también se ha estado trabajando mucho y se está generando una defensa especializada. Además de ello, trabajamos tanto desde Buenos Aires, en la República Argentina, como a nivel regional, intentando configurar redes. Para nosotros es sustancial el modelo de trabajo en red. Esto para nosotros es muy importante, porque además, otra característica que tiene la defensa pública de la República Argentina y algunas de las defensas del resto de los países, es que no solo representamos internamente, que representamos a víctimas y a victimarios en el proceso interno, sino que podemos llevar los casos al Sistema Interamericano de Protección de los Derechos Humanos y al Sistema Universal de Protección de los Derechos Humanos. De hecho, el modelo argentino, que es uno de los más superadores, tiene por ley asignado a la Defensora Oficial General de la Nación esto es, me tiene asignado al cargo de defensor o defensora general de la Nación la facultad de poder demandar al propio Estado frente a los organismos internacionales de protección de los derechos humanos. Esto se hace habitualmente y significa de muchísima utilidad, ya que hemos conseguido sentencias de la Corte Interamericana de Derechos Humanos sumamente claras en punto a fijar estándares en temas que hacen al respeto de los derechos humanos en los procesos, tanto civiles como penales. Todo esto configura un panorama muy importante porque la OEA, la Organización de Estados Americanos, ha reconocido que las defensorías públicas somos garantes de derechos humanos. Es decir, nuestro rol en la construcción de la democracia es lograr el respeto de los derechos humanos de todos y de todas. Por eso, agradezco mucho la oportunidad de contar esto para todos ustedes y también quiero instar desde este lugar para que se concrete la conformación de la Red Internacional de Prestadores de Asistencia Jurídica. Nuestra experiencia a nivel regional y a nivel nacional del trabajo en red es valiosísima. Yo creo que es definitivamente fundacional para una defensa pública de alta calidad. Como sabemos, se dispuso en la resolución 67/187 de la Comisión sobre Prevención del Delito y Justicia Penal que se conforme esta red. Esa resolución fue copatrocinada, entre otros, por la República Argentina. Por ende, queremos que se continúe con el valiosísimo y tan necesario, sin ello no lo podríamos lograr, aporte de Naciones Unidas, una red internacional de prestadores de asistencia jurídica. Y por ello también sería nuestro deseo, y así lo pedimos, que esto quedara plasmado en el broche de oro de esta 14ª conferencia, que será la Declaración de Kyoto. Nuevamente, en nombre mío propio, en nombre de mi país y en nombre de todos los defensores y defensoras públicas de América, muchas gracias por esta oportunidad.
Chairperson, Your Excellencies, Heads of Delegations, ladies and gentlemen, peace be upon you all. First, I would like to greet all participants to this event, and I would also like to thank Japan for hosting this 14th Crime Congress. I extend my appreciation to UNODC and to the organizing committee. Chairperson, ladies and gentlemen, my country realizes the importance of access to justice for all, and what it leads to in terms of securing stability, security amongst communities, the rule of law, and the promotion of peace, democracy, and justice values. My country is entering a new era of freedom and justice. Despite the challenges that the country faces, it has adopted effective national policies in the field of criminal justice, aiming to reform the justice system and rebuild it on foundations that respect human rights and adheres to the international human rights principles, including the increasing attention paid by international instruments to human rights considerations in criminal justice, as embodied in international and regional instruments on the treatment of offenders, such as the Standard Minimum Rules for Non-Custodial Measures, Tokyo Rules, the United Nations Standard Minimum Rules for the Administration of Juvenile Justice, the Beijing Rules, the Convention on the Rights of Child, the Declaration on the Basic Principles of Justice for Victims of Crime and Abuse of Power, violence against women, and other related issues. Another aspect of this reform process is to upgrade professional and technical skills and to draft an ethical code of conduct for criminal justice practitioners, with a focus on developing the standards related to the criminal justice profession, such as the Code of Conduct for Law Enforcement Officials, basic principles on judicial independence, and the guidelines on the role of public prosecutors. Another important aspect is strengthening international cooperation, which is one of the core issues in the field of criminal justice in the modern era. especially in the light of the increasing rate of transnational organized crime, which is a reality that necessitates working to create and strengthen effective international cooperation to combat and eliminate such crimes. To this effect, my country has joined and ratified a number of bilateral, regional, and international conventions on international cooperation. In addition, there is a need to pay special attention to issues related to public security due to the increasing role of urbanization in facilitating crime, and the need for new strategies and methods to prevent crime and to benefit from new tools provided through technological developments to prevent and combat crime. Chairperson, ladies and gentlemen, my country has recently emerged from an era of tyranny and oppression under which it has been plagued by armed conflict in many of its parts. Therefore, it was necessary to consider the importance of adopting a transitional justice program through several mechanisms, the most important of which is a Transitional Justice Commission. The law for this commission is currently being developed, and discussions on transitional justice and the most appropriate mechanisms for Sudan are taking place. Transitional justice in its reconciliatory or corrective forms represents an exceptional measure that aims to address and redress the effects of unusual societal conflict. Countries emerging from tyranny and societies seeking stability after revolutions or decades of civil war have no means to address and redress the effects of such periods, except by exceptional means to commensurate with the nature of violations and breaches committed, in order to redress the violations committed and guarantee the human rights of their citizens. Transitional justice in its final form aims to restore social cohesion, achieve communal peace, and avoid the reoccurrence of such acts of atrocity. And despite of the different mechanisms of its operation, transitional justice is based on holding perpetrators accountable for the violations committed, redressing victims, compensating them, reforming state institutions, and reconstructing them in accordance with standards that prevent violations and respect human rights. There are many challenges along the road to transitional justice, on top of which is the inability to prosecute all offenders. Trials require personnel, facilities, and technical evidentiary tools compatible with legal standards, and this needs preparation, funding, and training. The experiences of countries that emerged from civil wars or from eras of tyranny and tried to rebuild their societies without going through true transitional justice paths showed how they are still mired in the darkness of injustice, corruption, and violation. However, there is evidence from the experiences of certain African countries, such as Rwanda and South Africa, that it is possible to leave behind the heavy legacy of the past and lay down foundations to prevent future violations. Yet still, one should keep in mind the specific conditions and contexts of each country with regard to the historical and societal contexts of the subject, dispute, or conflict. Although the Sudanese case is one of the most complex conflict situations witnessed at present, Sudan has examples of local justice mechanisms that are rooted in local communities that can be used and developed in order to create a unique model that achieves goals and justice in its relative form. Chairperson, ladies and gentlemen, we all know that there are tremendous challenges facing the implementation of
I would like to thank very much our high-level speakers for sharing these insights from their national context. And it is now my pleasure to introduce to you our expert panel. The experts work directly on ensuring access to justice for all, including victims of gender-based and domestic violence, racial discrimination, and pretrial detainees who are amongst those most impacted by the effects of the pandemic. I am looking forward to hearing about successful practices to ensure protection of their rights. We will listen to the following video statements. Ms. Dominique Day, chairperson of a working group of experts on people of African descent. The Honorable Ms. Diana Kavesta Mochache, Chief Magistrate, Head of Station, Kahawa Counterterrorism Court in Kenya. Ms. Sarah Hossain, the Honorary Executive Director of Bangladesh Legal Aid and Services Trust, BLAST, who was set to speak, and unfortunately, she's unavailable for compelling reasons, and we will therefore show a short video highlighting the important work of civil society organizations such as BLAST in reaching out to some of the most vulnerable communities in Bangladesh. And then Mr. Muhammad Tahir Iqbal Malik, advocate, Legal Aid Sindh region in Pakistan. And finally, Ms. Jan Bigel, Director General, International Development Law Organization, IDLO. And as we have heard from Ms. Gadawali earlier, UNODC and IDLO are in the course of finalizing a memorandum of understanding to enhance our partnership and cooperate even more closely in the delivery of technical assistance on the rule of law and access to justice. Dear experts, you have now the floor.
I am Dominique Day. I am the chair of the UN Working Group of Experts on People of African Descent. And I thank you all for allowing me to join you here today and make a few brief remarks. I really welcome this conversation. I think our understanding of peaceful and inclusive societies as inextricably linked to effective access to justice and rule of law is key and is a key resource for all of us, including those of us left furthest behind. I think the SDG framework, and particular SDG 16, gives us some important guidance in this regard. We know that access to justice is a key component to peaceful societies, and where there are appropriate conflict resolution mechanisms in place, we see that they serve as violence prevention and violence interrupters. And the courts also have confirmed the importance of anti-racism to peace and to prosperity. And we see the important role the courts and court systems in mandating active measures to investigate and to redress racist violence. Why am I focusing on race? Well, my mandate is to look at how people of African descent are able to experience, protect, benefit from their human rights worldwide. And this is a space where we've seen particular struggle to conceptualize full equality and equity over time. We know that access to justice and rule of law is often racialized, and the challenges of removing or mitigating systemic racism in law enforcement, in the operation of courts, in the operation of policy decision-making is an ongoing challenge. And certainly our failures number as greatly as our successes. We know that the war on drugs and our counter-narcotics policies may have functioned more effectively as tools for racial surveillance and control than actually to mitigate the trafficking, use, or sale of narcotics. We know that despite someone's racial group, the likelihood of use, trafficking, sale of narcotics is about the same, and yet globally, our prisons experience people of African descent incarcerated for drug crimes at significantly higher and disproportionate rates to others. So when we're talking about peaceful and inclusive societies, and we're talking about access to justice and rule of law, we can never really separate that from a conversation about race, because we know that our criminal justice system, we know that our civil justice system boils down to individual decisions in individual cases. And yet, if every individual arrest, if every individual civil and criminal case is resolved in a way that fails to see, recognize, and grant the same opportunities to people of African descent, we have a systemic problem, and we have a systemic perpetuation of white supremacy. What we've seen globally is that people of African descent disproportionately experience violence, including via weaponized hate speech, due to permissible environments that license racial bias, discrimination, and the marshaling of violence against them. We see all sorts of violence, but then, I want to focus for a moment. We also see hate speech, valorization of the historic trade and trafficking in enslaved Africans, valorization of the periods of legalized enslavement and inequality. And these spaces are incredibly impactful to normalize and habituate communities and decision makers to the possibility of violence against people of African descent and the permissibility of looking the other way. It is not a mistake that we are able to hear around the world right now cries that Black Lives Matter. It's not a mistake that we're able to track the violence of law enforcement and non-state sources towards people of African descent as being disproportionate and excessive. We look at ongoing practices like Zwarte Piet, blackface. We've seen a recent interview of a former member of the British royal family. We understand that there are ongoing social practices in our media, in our culture, and in our history and traditions that actually dehumanize people of African descent and further lay the groundwork for violence and inhumane treatment. In order to deprive someone of their human rights, the quickest route is to first deprive them of their humanity. And people of African descent, since colonialism and the trade and trafficking in enslaved Africans, have suffered from the construct of race as a mechanism to normalize atrocity. Initially, atrocity in terms of the exploitation of people's bodies, lands, resources, intellect. And even as those exploitations eventually became less legal or illegal, we still see the legacies of that here today. One of the places we're able to measure them most drastically is in the criminal justice system, is in our understanding of racial disparities in narcotics prosecutions, convictions, and resulting incarcerations, and our understanding that these are not proportionate across all racial groups. So sustainable development requires eradicating these forms of exploitation. This includes the exploitation of children, right? And we're talking about the exploitation of children. We're talking about also a large group of people who find themselves funneled through our justice system, tried as adults prematurely, often facing arbitrary detention or lengthy pretrial detention, sometimes without a hearing, sometimes without review. And this is a significant concern that exists in developed and less developed countries. This is a concern that that has not been resolved merely by development, because it's grounded, of course, not in resources or even in safety, but in perceptions of whose bodies are dangerous, whose bodies are valuable, whose bodies deserve the right to grow from childhood into adulthood. And for us to really think about SDG 16 and what equal justice for all really means, we also need to confront our perceptions, our legacies of our colonial mindsets, and our ongoing actions that may perpetuate or sustain systemic racism. If we really want to commit to the SDGs, we need to understand the operation of race in our decision-making that actually perpetuates inequality and inequity. So it's very clear to us in many spaces that the fair and equal operation of the rule of law is a significant requirement for peaceful societies and effective development. And yet, we also see racial profiling that we can measure that counters this fair and equal operation of the rule of law. We've seen time and again how resources directed on racialized surveillance and control actually may license certain forms of community lack of safety elsewhere. And we know that although discrimination against people of African descent was initially sanctioned by law, we continue to bear the burden of the assumptions, the norms, and the biases of that space. So some courts have actually started to think about this and to embed these understandings into their reasoning to really recognize that law enforcement action, particularly when taken against Black bodies, may actually reflect norms, biases, and assumptions that are not narrowly tailored to community safety or actual crime. In order to renegotiate how it is we understand safety, how it is we understand liberty, we need to take people of African descent out from being the fulcrum in the seesaw between safety and liberty. When we talk about law enforcement and we talk about how the state intervenes in our lives, we often talk about this balance between safety and liberty. And we say the more safety you have, the more restrictions on your liberty that may create, the more liberty you have, the more possibilities for lack of safety. And the big issue for law enforcement in most places is to adequately balance safety and liberty within a legal context to maximize people's happiness. And that's an important responsibility, right? That is actually what SDG 16 is telling us to do. However, for people of African descent globally, and particularly in the diaspora, we've actually seen this balance of safety and liberty looks quite different. As I was saying earlier with my questionable analogy, that Black people often feel like the fulcrum in the seesaw, the pivot point against which safety versus liberty is balanced. On some level, the safety that is balanced against liberty has not resulted in an up or down trade-off for people of African descent, but in a diminished access to both. Both liberty and safety are diminished, and that has been seen as an acceptable outcome by law enforcement, by policy decision makers, and by leadership in many countries around the world. But this actually isn't effective rule of law. This actually isn't effective access to justice, because again, it continues to rely on our tolerance for exploiting certain people. I'm in New York right now. If you come to New York, you will hear people tell you, and they have testified in court, that they're so frequently stopped by the police, they don't even want to leave their houses, that they experience the lack of safety in their lives as coming not from community, but from law enforcement, from the state. And they experience a lack of liberty because on some level, even to leave their house is to license the impermissible search and seizure of their bodies, irrespective of whether they've actually done something wrong or there is actual reasonable suspicion or probable cause. This isn't a small thing, right? When we're talking about SDG 16 and we're talking about how this plays out, it is significant if a part of the population, if a large and sizable minority, if all people of African descent in the diaspora have to think about if they will lose their lives during a police encounter or a car stop. It is not a small thing to understand that some people's notions of safety have diminished both the liberty that people of African descent have and the safety that they would enjoy. And yet, renegotiating this from a fair, just, and equitable standpoint has proven very, very difficult, has proven nearly impossible. We released a report right in the middle of that first year of our COVID epidemic, when I think all of us were struggling with what does it look like to meet this moment, and also how are people surviving? And we put out a call for submissions around the world, and country after country, we heard that people of African descent were being disproportionately targeted by police for stops in the name of COVID enforcement, that people of African descent were experiencing tremendously high rates of police violence. And this is in the context of our understanding from the very beginning of the pandemic that people of African descent were at higher risk for infection, severity, and mortality due to COVID. The response of the state, the response of police in many states was not to protect, but instead to enhance the risk, to enhance violence, to enhance contact with jails, with prisons, with hospitals, with unmasked police officers, and to do so with impunity. We heard this reports from the United States. Many of these were published on video. We heard this reports from the United Kingdom, from Spain, from Italy, from Colombia, from Brazil, from Peru. And we also saw intense actions by these states to avoid counting people, counting what the impact was of this pandemic and this moment, using data disaggregated by race. These choices are not neutral choices. In a moment of pandemic where who has the luxury to quarantine is largely driven by racialized concerns. Who has the luxury to walk outside without being stopped by the police is highly racialized. It's not a small thing that there has been impunity in the ways that law enforcement has intervened when given a mandate to help protect a population. So I think I'll leave it here. The importance of this moment, I think, is still evolving. And one of the things I think we may learn from this year, a year in which many, many arrests have not happened, and yet community safety has not been drastically reimagined, and in which many, many unnecessary enhancements of risk have occurred in certain spaces. It may be that we're able to take important information from this year to rethink how we approach our own commitments to the SDGs, and specifically to SDG 16. I think this conversation is really key to that question. And I thank you all for allowing me to participate, and for your own work in engaging in this struggle to navigate our commitments to the SDGs towards greater justice for all and greater justice in communities. Thank you.
COVID was quite unprecedented. We obviously had our own challenges in the criminal justice sector, but then COVID caught us off guard. So as soon as the first COVID case was announced by the president, the Chief Justice and the National Council on Administration of Justice called for an urgent meeting. In attendance was the Inspector General of Police, the Director of Public Prosecutions, the Director General, Kenya Prison Service, and the Law Society, of course, Law Society of Kenya President, among other major stakeholders. They agreed on how they would be able to ensure that COVID does not get into prison. Secondly, how are we going to deal with offenders who are usually rounded up by the police and kept in the police cells? It was agreed that once the police have arrested petty offenders, they should be released on free bond, or they should encourage out-of-court settlement at the police station, and only serious offenders were supposed to be brought to court. With that, judicial officers were asked to work on alternate days so that we also do not congest the courts. So if one judicial officer worked on Monday, he or she would take a break, another one would come in and work the following day. And this way, then we had offenders coming in bunches. so that we do not crowd the courts. And then just following the Ministry of Health protocols, we encouraged social distancing in court. So you would find like there were only maybe 2 or 3 advocates and 3 offenders and the police officers escorting. And we also got sanitizers from the Chief Registrar of the Judiciary, and every person was supposed to be masked, and the government provided masks for all of us. Importantly, the judiciary now embraced technology. Every magistrate was given a new laptop. Judges were also given new laptops. Those of us who were technologically challenged were trained very, very quickly. And then magistrates and judges who have pre-existing medical conditions were encouraged to work from home. So we embraced virtual hearings. You would find the court assistant is in court, the magistrate is in the house, and the prison officer produces an offender in prison, and the court would continue hearing the matters. If you look at our bond bail policy guidelines, any person who has committed an offense which attracts a sentence of less than 6 months is not supposed to be taken to prison. But then when with the outbreak of COVID-19, it was established that there were so many petty offenders in prison serving less than 12 months. So when the NCAJ sat, it was agreed among the stakeholders that every court sits with its CUC, that is court users, and look at how many petty offenders were in prison. Working together with the probation officer, the magistrates prepared files and handed over to our high court judges to decongest the prison. We had to become very innovative. For example, in my court, if a serious offender could not be able to raise a surety to bring his village elder or to bring the area chief to come and vote that this person resides within his jurisdiction and he has a permanent home, and he'll ensure that the person attends court. That was sufficient to release these persons on bail. Article 48 of the Constitution states that every person is entitled to have access to justice, regardless of the status of the person. And when you look at Article 159 of the Constitution, Article 159 sub-article 1 states that judicial authority is derived from the people, and it shall be exercised by judicial officers in accordance with the Constitution. So the first question that comes to mind is, how do the people of Kenya, how did they want us to proceed in criminal cases? So when we look at Article 159, it encourages ADR and alternative justice system. It became very imperative that we now embrace alternative justice system to imprisonment. With the coming of COVID, now as stakeholders in the criminal justice system, it was not ideal to send many people to prison. Most of us now embraced diversion as a form of punishment. And the people, let's say at the coast, the offenders who abuse drugs were sent to rehabilitation centers instead of being taken to prison. Petty offenders were placed on community service, or they were sentenced to serve probation. We were also encouraged to adopt suspended sentence, which was rarely used. As judicial officers, if we embrace Article 159 of the Constitution, then we will have a better society where not all offenders end up in prison, but then they are reconciled and they continue operating from home.
আমি শুভা সরকার, জুনিয়র অ্যাডভোকেসি অফিসার ব্লাস্ট। করোনা ভাইরাস সংক্রমণকালে এই সময় আপনি নিরাপদে আছেন তো? আমরা সবাই করোনা মোকাবেলায় এই সময় সামাজিক দূরত্ব বজায় রাখব, নিজ ঘরে অবস্থান করব ও স্বাস্থ্যবিধি মেনে চলব। কারো মাঝে যদি কোভিড-19 লক্ষণ দেখা দেয়, তবে পরামর্শের জন্য যোগাযোগ করুন স্বাস্থ্য বাতায়ন হেল্পলাইনে 16263 নাম্বারে। হিজড়া ও লিঙ্গ বৈচিত্র্যময় জনগোষ্ঠী যারা দৈনন্দিন উপার্জন দিয়ে জীবনযাপন করেন, এই চলমান পরিস্থিতিতে প্রতিনিয়ত জীবিকা, খাদ্য, উপার্জন, স্বাস্থ্য সুরক্ষায় অনিশ্চয়তায় ভুগছেন। তাই আমাদের সামাজিক দায়িত্ব এই সময় তাদের পাশে দাঁড়ানো। আসুন আমরা তাদের জন্য প্রয়োজনীয় খাদ্য, স্বাস্থ্য সেবা ও সহযোগিতা নিশ্চিত করি। এই সময়ে তাদের প্রতি সকল প্রকার বৈষম্যমূলক আচরণ ও সহিংসতা পরিহার করি। আর হিজড়া ও লিঙ্গ বৈচিত্র্যময় জনগোষ্ঠী, আপনারা বৈষম্যমূলক ও নির্যাতনের শিকার হলে বিনামূল্যে আইনি সহায়তার জন্য ব্লাস্টের হেল্পলাইনে যোগাযোগ করুন 01715-220-220 নম্বরে। ব্লাস্ট সব সময় আপনাদের পাশে আছে। প্রয়োজনে এবং সহিংসতা নিরসনের জন্য ন্যাশনাল ইমার্জেন্সি সার্ভিস 999 নম্বরে যোগাযোগ করুন। আসুন করোনা ভাইরাসে বিস্তার প্রতিরোধ করি, আতঙ্কিত না হয়ে সচেতন হই। সংকটময় এই সময়ে করোনা করব জয়, নিরাপদে নিজ ঘরে থেকে।
Excellencies, ladies and gentlemen, the promoting rule of law and ensuring equal access to justice for all is a fundamental right. This is also part of 2030 Agenda for Sustainable Development. In Pakistan, access to justice fair trial is a fundamental right, and state is responsible to provide inexpensive and expeditious justice for all. Currently in Pakistan, 114 prisons are functioning. These prisons are 34% overcrowding against the authorized capacity. In Pakistan, some organizations working on speedy and expensive just legal aid to the poor and UTPs like UNODC Legal Right Forum. They are providing legal aid to the poor, marginalized communities, women, juvenile, person with disabilities, minorities, mentally ill and transgender. No, I am talking about the province in Pakistan. There are 24 prisons in Sindh, including Central, District and Special Prison for Women and Juvenile. In the month of Feb 2021, total population in Sindh prison 17,739, in which 501 juvenile and 271 women. They are also 33% overcrowding against the authorized official capacity. Today, I am here presenting the best model of legal aid project from Sindh, Pakistan 2020. Under this project, legal aid has been provided successfully to the 515 UTPs, in which 11 women, 16 juveniles, 6 minorities, and 4 PWDs, 1 mentally ill, and 1 transgender. Best practice of the project is following. Number 1, coordination and cooperation. This is a best practice of the best coordination and cooperation between prison, legal aid lawyer, including Bar Council and Bar Association. Localization. Selection of 21 gender-based legal aid lawyer, including 1 team lead, 5 senior level, 10 junior level legal aid, and 5 paralegal expert on open merit from the local level. Selected as a district Karachi, Hyderabad, Sakkar, Ladkana, and Jacobabad. Number 3, during COVID-19 pandemic outbreak, we have development contingency plan with the consultation of Home Department, Government of Sindh, and Prison Authority. This is the first time developed any contingency plan for prisoner and legal aid in across Pakistan. LMIS also developed legal aid management information system has been developed. Paralegal expert feed data on daily basis, and also case flow management system. Sindh High Court also CFMS and district judiciary feed in data on daily basis on CFMS. Our team, like paralegal expert, match the daily diary and data with the CFMA and LMIS. Procedure of legal aid we have adopted in this best project. Number 1, situation analysis and roadmap for the provision of legal aid UTPs were conducted. Number 2, selection criteria was also developed. Legal aid team in consultation with prison department was finalized selection criteria for the all UTPs. Number 3, any UTP submit application for legal aid office as well as to the member of the prison office. All requested legal aid cases are recorded and registered. all legal aid lawyer, regular visit, central prison, district prison, special prison for women, youthful offender industrial school, and meet UTPs, conduct interview for legal aid if he is eligible for legal aid as per developed criteria and approved from the prison authority, then to provide legal aid, otherwise regretted. Once UTP is selected for legal aid, team will be provided legal aid until disposal of the case. The legal aid lawyer ensure to the provision of speedy, inexpensive, expeditious justice to the all UTPs. So we can say this is the best model legal aid project, best coordination, cooperation between the prison, prosecution, legal aid lawyer, including Bar Council and Bar Association. Lesson learned and future recommendation. Legal aid should be continued in collaboration with private-public partnership, government, legal fraternity, UN agencies, and local non-governmental organizations. Alternate modality must be strengthened, such as probation department, counseling, rehabilitation, reintegration, and payroll department must be strengthened. Prison legal right awareness campaign must launch in the all prison. Besides increasing the capacity and facility of prison and Sindh, deserving UTPs should be given to compulsory legal aid by the state to decrease the population of UTPs in all prison. Government should institutionalize legal aid mechanism and establish a Sindh legal aid authority, whereas the legal aid should be provided to all through a one window operation. Their legal aid program reduce prison population, ensure equal access to justice, and rule of law will be strengthened. Thank you very much for listening.
Excellencies, distinguished delegates, colleagues and friends, it is a pleasure to join this eminent panel on the critical issue of equal access to justice for all, which is at the heart of the work of the International Development Law Organization. IDLO works in every region of the world, including in some of the most fragile contexts where justice and the rule of law are most at risk and where rights are under threat, serving the most vulnerable among justice seekers. Access to justice and the rule of law lie at the heart of inclusive and sustainable development. They're also critical to building and sustaining peace. Many root causes and drivers of conflict and instability, such as impunity, corruption, human rights violations, and lack of accountability, are linked to an absence of justice systems and the rule of law. This was recognized in the 2030 Agenda for Sustainable Development, most prominently in Goal 16. But justice only becomes a lived reality when people can access it. And for too many people around the world, it remains unattainable. Even before COVID-19, over 1.5 billion people had a justice problem that they could not resolve because they did not have means to reach a court or afford legal assistance, because they were unaware of their rights or how to exercise them, because legal procedures were too complicated and cases dragged on for years, or because they were excluded or discriminated against in law or practice. Like other aspects of public life, justice systems have been hard hit by the pandemic. Restrictions on physical access to courts and tribunals and the slowing down of operations have coincided with a sharp rise in the need for legal protection and services. Over the past year, as part of our contribution to a rule of law-based response to COVID-19, IDLO has worked with governments and civil society to address emerging justice needs. Necessity is often the mother of invention. While COVID-19 laid bare the consequences of years of underinvestment in justice systems, it also challenged us to innovate and explore alternative approaches. In Kenya, for example, IDLO supported the judiciary to keep courts operational during lockdowns by developing electronic case filing and management systems. In the Sahel, we launched a program to strengthen criminal justice chains, making them more efficient, accountable, and respectful of human rights through the use of community engagement platforms. Drawing on our experience, I would like to share 3 ways in which we can work together to accelerate progress towards ensuring access to justice for all by 2030. First, closing the justice gap and promoting a just, sustainable, and equitable recovery from COVID-19 will require reimagining justice systems with people at their center. We must recognize that people resolve their disputes and access justice through through diverse pathways, and prioritize reforms and innovations to increase access and inclusion and produce fairer outcomes for justice seekers. This includes equitable digital innovation, expanding legal aid, leveraging alternative dispute resolution and customary and informal systems, and adopting more restorative approaches to corrections. Secondly, ensuring access to justice for those most at risk of being left behind, particularly women and girls, must be a priority. Gender equality is first and foremost a fundamental human right, but the full and equal participation of women and girls in all aspects of public and private life is key to the implementation of the 2030 Agenda. Along with UNODC and other partners, IDLO released a report last year on justice for women amid COVID-19, highlighting how the pandemic is further increasing the staggeringly wide gap of injustice and inequality that women face across the globe. The dramatic increase in intimate partner violence during times of lockdown is a clear example. Over the course of 2020, IDLO has adapted its work on combating gender-based violence to address the increased demand for support and services for survivors. In Afghanistan, for example, we have been supporting women's shelters, which saw numbers of survivors seeking refuge double in some cities. My third and final point is that we must act urgently to reverse the alarming decrease in political and financial support for justice and the rule of law. Surveys such as those conducted by the World Justice Project have shown consistent negative trends: rising authoritarianism, lack of trust in public institutions, closure of civic space, and increased human rights violations. And all of these have been exacerbated by the pandemic. Spending on the legal and justice sector as a share of ODA and national budgets has also declined and is likely to be further affected by the economic crisis generated by COVID-19. These trends have grave implications, not just for the goal of ensuring access to justice for all, but for the achievement of the entire 2030 Agenda. But another lesson of the pandemic is that we are all in this together. The crisis has shown what can be achieved through cooperation and solidarity. Partnerships will be key to driving change. IDLO is privileged to work with partners like UNODC to advance our shared commitment to ensuring access to justice for sustaining peace and development. As part of our efforts to facilitate new partnerships and share information on challenges, innovations, and good practices, IDLO is co-organizing with Italy and UNDESA a global multi-stakeholder conference on SDG 16 next month. It will be an opportunity to take stock of the current state of play on how goals related to peace, justice, and inclusion have been affected by COVID-19, and to explore ways to accelerate progress on SDG 16. I welcome all of you to join us from April 28 to 30. Investing in a culture of justice is the surest way to manage the current crisis, build resilience to future shocks, and work towards a more peaceful, just, and inclusive future. My colleagues and I look forward to working with you all and other champions to help make justice for all a reality. Thank you.
In concluding our special event, I would like to thank all our speakers for sharing so many important points of view on ensuring access to justice for all. You provided food for thought on what governments and practitioners can do to actively build capacity, tackle institutional reform, and help justice systems address the impact of the pandemic and beyond. UNODC is committed to continue supporting member states, community organizations, and justice actors to develop strategies and build the skills among practitioners and managers to empower those left behind. In partnership with actors on the ground, our assistance aims most of all at enabling people to actively participate in society and achieve meaningful justice by reforming police institutions, overturning wrongful convictions, empowering victims and preventing their re-victimization, training lawyers, public defenders, paralegals, and other professionals to better respond to the needs of their client, and working towards the release of persons from pretrial detention so that they can return to their communities. Our new UNODC strategy and the recently launched UNODC Strategic Vision for Africa 2030 both put people at the center, and access to justice for all is a key enabling factor in those strategies. Finally, I would like to thank our audience and all those who prepared, supported, and contributed to this event. Thank you very much.